Once there's been an order entered for custody, visitation, and child support, you may end up back in court. And usually that's in two circumstances. One is a modification of the order, which means a change in the order. The second way you may get into court would be what's called an enforcement or contempt. And that's where papers are filed saying that one party has disobeyed part of the court's order.
A child support order can be modified as a result of a change in the earnings of the non-custodial parent, and the child support order can be increased or decreased. And it's based upon either a loss in a job or a non-custodial parent getting a new job or getting a substantial raise in their new employer. And so when we're made aware of that information, then the case is assessed to determine whether or not the child support should be increased or decreased, or if it should remain the same.
When we need to enforce an order that's not being complied with, when child support's not being paid, we can take a wide array of actions. They can be administrative actions. We may start off with making collection calls to the non-custodial parent, trying to figure out what's preventing them from paying. We'll send written correspondence regarding their delinquencies. We also have other administrative actions such as license suspension.
The steps that we can take to enforce a child support order beyond the wage withholding process is to bring the party back into court and ask the court to hold them in contempt, and where they are put on either community supervision or supervision where they're having to report to an officer in usually a county office and report to them regularly about employment as well as whether or not they're paying their child support. And if they're not willing to comply with the order at that point, the Attorney General's office can also file what's called a revocation. And it's usually at that point, if not in the first stage where we're asking for contempt, that we're asking for them to serve some time in jail.
A visitation order cannot be modified by the Attorney General's office. The Attorney General's office is required by state law to establish a visitation order at the time we obtain the initial or the first order in a child support case. However, subsequent changes to that visitation order must be handled outside of the Attorney General's office with either the custodial parent or the non-custodial parent handling it, that visitation change on their own or through the assistance of a private attorney.
There's a misunderstanding that if a victim doesn't receive a child support payment, then they don't have to provide access and visitation. Just because you don't get your child support check doesn't mean that you have the legal right to not provide access to the child. The two are separate.
The court often sees situations where the person with custody has been sued because they are violating the order concerning visitation. It's very important that the court knows up front what you're asking for in visitation, and if you want a very limited or supervised or even no visitation ordered, that you be ready to tell the court why and present as much evidence as you can as to why. That's why it's also important not to just agree to something in court because you're tired or intimidated and you just want to hurry up and go away that day. If the court enters an order that's bad for your child because they don't have the correct information, it could be very difficult to change it.
If you ever have any concerns about the way that your case is being handled, you can ask to speak with a supervisor or a manager. Every office also has an ombudsman who's there to address customer concerns. So all you have to do is ask, and we'll make sure that your concerns are elevated.
If a party has had a hearing in court, and either the next day or at some point later, they either don't like what the court did or feel that the court did not receive enough information, there are some appeals processes, but both of them are very limited time frames to do. It's very, very important not to sign an order that says it's your agreement if you do not agree to it. The court cannot go back and undo that without the rules being followed. In the first case, you could file what's called a de novo appeal. What that basically means is starting over. You would go to the court where the case was filed, and on your papers at the top it would say in the county court at law number 4 of Williamson County, or in the district court of Burnett County or Harris County, and that's where you would file that paper. You would have to write out what it is about the order that you do not agree with, file it with the court, and then you have to send copies to the other parent and to the Attorney General's office and request a hearing. That has to be done within 7 days after the order has been entered. And so it's a very quick time frame. If you've missed that time frame, you can also file what's called a motion for a new trial. But again, that has some very specific rules, and if you do not do it correctly, it cannot be granted. It has to be done basically within 30 days after the court has ruled. You have to send copies to the other parties, and you have to set it for a hearing.
At the Office of the Attorney General, we really want you to know that we are concerned about the safety of you and your children, and that we want to work with you through this process to make it safe and ensure that you have an order that will work for you.